is an appeal in the matter of Mackenzie and Cheung and another.
Yes, now Mr. Warwick, Mr. Fain, before we begin, can I just say that we have the honour of the presence of a judge of the Cour de Cassation in Paris. Judge Lombre is a member of the commercial section of that court, and she's here to observe our proceedings.
Thank you, my lord.
Yes.
Well, my lords, in this matter I appear on behalf of the claimant stroke appellant, leading my learned friend Mr. Henry Moore, and the defendant respondents are represented by both Carl Fain, leading Richard Miller. As you know, this is the second appeal brought with the permission of Lord Justice Snowden, and if I encapsulate the broad topic in one sentence, it is concerned with the proper approach to a release stroke variation provision at the end of a list of specific covenants, where the specific covenants are binding by reason of annexation and not as part of a building scheme. Without using the word roadmap, which I don't like, so I won't be telling you the roadmap, but a list of topics to be covered are in this order. I'm going to deal with the context for the case, both geography and legal, then secondly look at the conveyance, then make submissions on behalf of my client, and then fourth, fifth and sixth look briefly at the Deputy Master's judgment, the judgment of the judge, and make some comments on my learned friend's skeleton argument. So that means I'm going to begin with the context, both geographical and legal. Geographical, we can get out of the core bundle because there is a planning permission and a report from an officer therein. So if you were to take up the core bundle and turn to page 110, we have there 24th of March 2020, the grant of the planning permission in favour inter alia of the second defendant, and it's for the demolition of the existing dwelling at this property, 444, and the erection of 9 residential apartments. So you've got that description and the address there, and then there was a report which can usefully be looked at briefly, beginning at page 120, and in the summary of the application details near the top, you've got the description again, the demolition of the existing dwelling and its replacement with 9 flats. And then if we turn over a little bit and go on to page 122, we see there at paragraph 3.3 and below a description of the site and the surroundings, and there's a photograph, and the photograph shows with a red edging the subject property, and also if you look around you can see there are other properties in the vicinity, all seem to be detached dwelling houses. The planning permission was the subject matter of quite a lot of objections. If you turn to page 123 at the bottom of the page, you'll see there are 171 responses, 173 responses, of which 171 were objections and 2 were supporting. There's a list of objections. One of those, and that's the crossover between planning and this case, is at the top of page 127, very first line: restrictive covenants on the land prevent development across the building line or erection of more than one single detached dwelling. And of course the planning officer correctly recited it was a private matter for the developer and is not a material planning consideration. So it may not have been material for planning, but certainly was very material and is very material to the many local residents and who will be affected by the decision of this court, one way or the other. Now, the legal context can be gleaned from the particulars of claim, because all the basic facts, by way of background, are all admitted in the defence. If we were to go to the particulars of claim, still in the same bundle, the core bundle, and go on to page 91, this conveniently introduces us to the relevant properties. So paragraph 1, my client, the claimant, is the registered proprietor of 432, and it gives you the details of his registration at the land registry, and it's described as the benefited property. And then the first defendant is the current registered proprietor of number 444, and that's also registered, and there's and that's described as the burdened property. And the second defendant I've already mentioned is a developer and has the benefit of an option to buy number 444. Over the page there's the restrictive covenant. I'm going to come in due course to the details of the conveyance. I'm not going to read out paragraphs 4, 5 or 6 because they're part of the background, but go on to paragraph 7. At the date of the conveyance, the adjoining or adjacent land that was then the property of the foundation was part of the governor's Fox Farm estate, and some of it was undisposed of. And the part of it that was undisposed of was 432, the benefited property. And paragraph 8 tells us that at all material times the title to 444 has had an entry on the title recording the reference to the restrictive covenants. And 9, the first defendant became subject to the covenant in 2018, and my client then acquired 432 in 2013 and is duly registered. And paragraph 11, up to and including 11, these are all agreed, admitted in the defence, and by operation of section 78, it is enforceable by my client. And indeed, as we are standing, or most of us are sitting here, it's still binding, because my understanding is that no deed of modification, abbreviated to DOM, has yet been executed. It's all pending the result of this litigation. This is a case, as I've already outlined, where the restrictive covenant is enforceable by reason of annexation. And that is because the original conveyance of my client's house, 432, postdated the original conveyance of the first defendant's house, 444. Now, I apprehend that your lordships will be familiar with the principle of annexation and the contrast between that and a letting scheme. But to emphasise, and I apologise if this is rather repetitious of your knowledge, I wanted to take you briefly to some comments of Jonathan Parker, Lord Justice, in the Whitgift case, because it usefully contrasts the position. And I don't think I did this in the court below, and as it is, when counsel misses something out, you wonder whether that's what's made the difference. So if you could kindly take up the bundle of authorities, and you'll find that the Whitgift case is tab 3, beginning at page 21. This was an appeal to this court from a decision of Mr. Justice Newberger, as he then was. And I'll just set the scene by turning to the beginning of the judgment, the introduction by the Lord Justice. He says it's the reciprocal enforceability of restrictive covenants imposed on neighbouring properties forming part of a single developed estate. And I should say at the outset, this case doesn't help you with the particular issue that we've got in this case, but it's to set the scene. And there was Whitgift Homes was a property developer which had an option over 2 residential properties known as 14 and 16 Ruffets Close, as it happens in South Croydon. And Whitgift Homes was the first defendant, and the second named appellant, Mr. Callaghan, was the owner of 16, and he's the second defendant in the action. And the third and fourth defendants were owners, but they had sold the property and they dropped out of the picture. And the respondents, who were the claimants in the action, were 55 owners of adjoining or adjacent properties. And there was no dispute that they all derived title from a common owner. And then looking at 5, there was a conveyance in 1932 whereby the developer sold off 16 Ruffets Close to a predecessor of Mr. O'Callaghan, and there was another conveyance only a couple of weeks later where 14 Ruffets Close was sold off to a predecessor of the Hinckleys. Each of them contained restrictive covenants, and the appellants proposed to develop 14 and 16 Ruffets Close. And then there's a couple of paragraphs talking about the burden, so I will skip over that and go to paragraph 8, which contrasts the 2 types of annexation, or that deals with annexation and the next one scheme. The benefit of a covenant will pass to a successor in title of the covenantee if it relates to, the old expression was, touches and concerns his land, and it's been either assigned to him or annexed to his land. There were no assignments in the present case. Annexation in this sense can only occur in circumstances where the land to which the benefit of the covenant is said to be annexed was in the ownership of the original covenantee at the date when the covenant was entered into. Thus, the effect of annexation in a case where the developer of an estate sells off various developed plots subject to restrictive covenants is the first purchaser will not be able to enforce the covenants entered into by the purchasers of any of the other plots, whereas the last purchaser will be able to enforce the covenants entered into by all the other purchasers. And in the instant case, the owners of those of the respondents' plots, which were sold off by the developer before it sold off 14 and 16 Ruffit's Close, cannot claim the benefit of the covenants by annexation. And you'll see, in fact, there were very few people who were able to enforce. And then there's a contrast at paragraph 9 with the scheme, because in this particular case, both scheme and annexation were an issue. The existence of a scheme where similar restrictive covenants are imposed on a number of properties in a defined area are mutually and reciprocally enforceable as between the respective owners for the time being, and is then referred to as a building scheme. And then the owner for the time being of each of those properties will be able to enforce the covenants against the owners for the time being of each of the other properties subject to the scheme. Thus, in the case of an estate which is sold off by a developer in various plots, the owner for the time being of each plot will be able to enforce the covenants against the others for the time being of all the other plots, regardless of whether the plots were sold off by the developer before or after his own plot. So in the instant case, if such a scheme exists, each of the 55 respondents will be able to enforce the covenants. And what happened is, and in fact in this case, there were denials either that was annexation or that there was a scheme. And Mr. Justice Newberger found, as you'll see at paragraph 11, both in favour of the scheme issue and in favour of the annexation issue. And so there was an appeal. There were, as you've seen, 55 people were affected, or 55 properties were affected by the scheme issue. There were only 3 who could say that they were later in time, so they were benefiting from the annexation issue. And the Court of Appeal disagreed with Mr. Justice Newberger on the scheme issue, because that's not a point in issue. I'm not going to trace that through. I can if necessary. But so the Court of Appeal disagreed with him, but they agreed with him on the annexation. So there were 3 people who were left who were able to enforce. But the way in which the covenants come to be enforced, maybe, we say, probably is important in the context of this case. Now, that's the, as it were, the legal context as well as the geographical context. And so now I'm coming on to my second topic, which is the conveyance and the enforcement of its terms. But before looking at the conveyance itself, it's rather helpful, I think, if I set out the rival viewpoints in just a few lines. The defendant's contention, and I take this inter alia from paragraph 34 of the defendant's skeleton, is that paragraph 11, that we've probably already read about, and we'll look at again in a moment, grants an absolute power of release. And they say it's an absolute power of release both for plots to be sold by the charity, the Whitgift charity, but also in respect to plots already sold. And they submit that this power is unqualified and is exercisable forever. So it's couched, they don't shrink from this, it's couched in they say the result is very, very wide, couldn't be wider essentially. We submit 3 things. First of all, we submit that this construction is contrary to the legal context, which I've said a little bit already. Secondly, it's contrary to the construction of general powers of release or variation. You get, not just in property field, but you get in the contract field generally, a whole list of powers, or sometimes a particular power, and then a power of release, or couched as a power of variation sometimes. And the courts generally construe these general powers of release or variation so as not to take away specific rights that are enjoyed. And the courts arrive at that by a couple of different routes, and sometimes they refer to them both. Sometimes it's done by invoking the doctrine of derogation from grant, and sometimes it's done by just reference to general principles of construction. And that principle can often be stated as you have to have very clear words before you take away specific rights. And so although on the face of it, and we'll see this in 1 or 2 examples, you've got words that look as though they are wide enough to enable a variation or a change. In fact, when you consider them in the context of the document as a whole, the contract as a whole, they don't work. Now, the third point I make, just as a flagging up at this stage, is in the nature of a fallback, because I say we don't even need to rely on this, but if in fact, regardless of what I will be submitting under points 1 and 2, there is real overlap, or maybe even surplusage of part of paragraph 11 as opposed to another part of paragraph 11, I will be pointing out, and again, you're probably familiar with this principle. Lord Hoffman described conveyance as often adopting torrential drafting, where you have one phrase being repeated or in different words, and Lord Newberger said that surplusage in the realm of conveyancing carries little or no weight, and there is one case that conveniently summarises other principles all on the same topic, which I will come to rather later in my submissions. So we will say that even if there is real overlap, that doesn't matter. That's not a reason to find in favour of the respondents. So now, with that backdrop of the positions of the two parties, I now come to the conveyance. I apologise in advance that the fact that the printing of this isn't terribly good. I inquired of my instructing solicitors as to whether there was something better, and was told there is not. So I'm going to be reading some parts of it, just to be sure that we can all see what's going on. We're into the core bundle still. It's on page 156 is where the conveyance for 444 begins. And so starting at the top, 3rd of October 1947, between the trustee of the charity lands, called the trustee acting by the governors of the first part, and Mr. Marshall, being the governor, being one of those specified in the first schedule as the governors, being of the Whitgift Educational Foundation, called the governors of the second part, and then the individual person who was the owner or the buyer, Henry Vernon, the purchaser of the third part. And then we've got the hereditaments hereinafter described and intended to be hereby conveyed form part of the property of the foundation and are held on charitable trusts for educational purposes. So the hereditaments are essentially, as you'll see, the plot in question. And indeed, we'll come to it again in a minute, but if we want to look at it straight away, it should be the last page in this bundle, page 162, and it's literally called plot 200, with the red edging around. That's recital 1. Then there's a reference to the governors of 2. In 3, there's a reference to a scheme that goes back to the time of Queen Victoria. And 4, slightly more interestingly, there's a reference to an order of the Minister of Education of the 14th of March 1946, whereby the governors were authorised within 3 years from the date hereof to sell the said hereditaments at the price of £280. The plot was to be authorised. We seemingly don't have the order, but that's what we're told about it. And number 5, the governors have agreed to sell the hereditaments to the purchaser at the price of £280. And these presents have been duly approved. There's been a resolution of the governors. So over the page, in consideration of the £280 paid to the governors by the purchaser for the purchase of the fee simple of the hereditaments, the governors, in the name and on behalf of the official trustee, convey and confirm unto the purchaser all the piece or parcel of land situate in the parish of Croydon, and then it gives the frontage, and it says more particularly delineated on the plan annexed here too, edged with red, and that's the plan that we've just looked at. And then there's a further definition in relation to this in the second schedule, but that really takes us back to the plan. And then we've got at 2, the purchaser for himself is sequels in title and assigns to the intent that the covenant will contain shall run with the land and bind the same into whoever's hands the same shall come, but not so as to render the purchaser his sequels in title and assigns personally liable in damages after they shall have parted with all interest in the property conveyed, covenants with the governors and their successors and assigns for the benefit of the adjoining or adjacent land, now the property of the foundation. So this is for the benefit of what's left. And being that part of the governor's fox farm estate remaining undisposed of at the date hereof, and every part thereof, the purchaser his sequels in title and assigns will at all times hereinafter observe and perform the stipulations which are contained in it. It says second schedule, but its common ground is the third schedule. And then there's a reference to the tax consequences. There's a list of the names of the governors, and second schedule was referring to the plan. And then the covenants. Now, rather than just immediately go to the critical covenants, it's important to see what else is going on here in the third schedule. So there's a reference to a footpath, which I don't think I need read at 1. And then 2, there's a reference to the purchaser maintaining, putting up and maintaining various fences. And those fences are all set out in detail in paragraph 2. And then 3 has got a building line requirement. No building or erection except boundary walls.
Could I just ask you, as we go through these, who in totality has the right to enforce, for example, 1 or 2?
Presumably, the governors or the
yes. So these represent continuing ties, as it were, between any future purchasers for any period of time and the governors.
Yes. As they stand in the form that they are.
Yes, I mean, this is why I agree with you. It's interesting to see the clause 11 in its context.
As you see, there's some which are, I was going to say unambiguous, that's not the right word. There's some which are absolute,
yes.
And then there's others which are subject to consents. So
and since I asked you, you've given the instance of the governors having the right to enforce these covenants, for example, boundary markers. Anybody else have the right to enforce those covenants against a particular purchaser?
Well, if they were negative, then they would be the sort of covenants, restrictive covenants, that could be enforced by a successor in title, someone like my client. Distinction to be made between restrictive covenants, which by long tradition going back to the Leicester Square case, Talk and Moxhay, which can be enforced by others, and positive covenants, which cannot be enforced.
Right, so in the case of negative covenants, it would not just be the estate, the original vendor, that could enforce, it would also be others who had obtained their own titles after.
Yes, by that, that's why I was enforcing or underlining the annexation point. They come later in time.
Okay, understand, thank you.
So then we've got at 3 a bar on certain types of building. No building or erection except boundary walls, fences and gates, none of which shall in any case exceed 3 feet 6 inches in height, shall be erected on the land lying between the road frontage and the building line, shown on the said plan, and the purchaser shall build strictly to the building line. So that is a prohibition, essentially, on what's to be done. 4, and then we've got two parts to 4. No earth, sand, gravel, clay or chalk shall be removed or dug from the property except for the purpose of erecting buildings thereon or laying drains therein, and no part of the land is to be used as a road or way or means of access to any adjoining property without the written consent of the governors being first obtained. So again, some prohibitions, and then really quite an important prohibition, particularly in the case of residential or land being sold for residential purposes. 5, no trade or business shall be carried on upon any part of the property, and no manufactory, mill, gasworks, hospital for contagious diseases or asylum shall at any time be erected upon or carried on the premises. Nothing shall be done upon the land which shall become a nuisance or annoyance to the owners or occupiers of adjoining property or to the governors. So this is all negative. This is plainly of very great importance to the adjoining owners, because indeed they're specifically identified. And so what I apprehend, my learned friend will have to say, is that the power for which he contends is such that even regardless of the date under which some conveyance is entered into, along can come the charity, and it can say, for the purpose, forgetting about planning, because obviously planning is separate, for the purposes of this, I'm going to authorise you to put up a gasworks or some other very nuisance-founding type occupation.
And of course, even on your case, the defendants couldn't stop you putting up the gasworks.
Well, not that way round, my lord, no. But there may well be other people, because there's obviously a lot of residents who have got detached houses in the vicinity, and in the usual way, what tends to happen, and your lordship will know this very well, is you check out the titles of the different people and you find who it is. So it wouldn't work the other way around. It's true, the first defendant wouldn't be able to take action, but there's until you get to the very last person, which is why part of the reason for my quote of the Whitgift case, till you get to the very last person, then there will be somebody who will be available probably to enforce the covenant.
But an earlier purchaser could not stop any later purchaser putting up the gasworks.
That's correct. That's correct. Indeed, that's the whole way it works. So that's 5. That's the no trade or business, etc. that is set out, and then we've got the next one, which is 6. Very difficult to read the number. No, this is hoardings. No hoarding should be erected on the land, nor shall any beaded erection fence on any part of the land be used for advertising station or advertising purposes or any description. So there's lots of different categories of activity that are prohibited under this. Then we come to the particular provision that is the subject matter of this litigation. No building shall be erected on the land except one detached dwelling house, and the stables or garage, offices and outbuildings thereto, which said property shall not be used at any time otherwise than as a private residence. So not only is it a detached dwelling house, but it's not something that can have multiple uses. And then 8, no building or structure of any kind shall be erected on the land until the plans and elevations and site shall have been submitted in duplicate to and approved by the surveyor for the time being of the governance. So this is one where you've got a prohibition, but there is it can work if the plans are approved, and the cost of the approval of the plans and elevations amounting to 2 guineas in respect of each house and submission shall be paid by the purchaser, and the governor shall retain a copy of their plans. And then the purchaser shall build strictly in accordance with the approved plans, shall not make any alterations or additions to the property, or add any further buildings without submitting plans and elevations of such alterations or additions and obtaining the approval of the governors. So very carefully controlled. Then there's a right to light provision, which I don't think is really going to help us. 9, and then the property has been the old-fashioned phrase stumped out in paragraph 10. And then we've got the paragraph 11, which is the core of the argument today. The governors reserve the right to deal with any of the plots situated upon this estate or any of their adjoining or neighbouring land without reference to and independently of these stipulations, and also reserve the right to allow a departure from them in any one or more cases. And at the moment I'm just reading, so I'm not going to be making lots of submissions in relation to that. So that's...
Before we leave this, I just wanted to go back to the gasworks clause, which is 5.
Yeah.
It just struck me as you were reading it that there are really 2 parts to that might the draftsman have formed 2 separate clauses. But there's something specific in the first part in this instance.
You're quite right.
And something very general in the second part of that clause. I mean, the draftsman doesn't appear to have been too particular about where one clause began and another clause finished.
Your Lordship's right that a number of these paragraphs or clauses have within them more than one subject matter, or maybe overlapping subject matters. So, for example, the preceding one, 4, you've got the no earth, sand, gravel, etc. shall be except for the purpose of erecting buildings, and you've got no part of it should be used as a road. So they seem to be rather different restrictions.
Yes.
Rolled in together.
But I agree with you that it's interesting to just look at the sort of drafting we have here.
Yeah.
When coming to consider the crucial clause.
Yes. Well, the governors have gone out of their way to create a whole set of very specific covenants, few of which are positive, but most of which are negative. And of course, it's there as part of this case, whether it was envisaged, as Melanie Friend will say, that none of these matter because the governors could come along and get rid of them all if they wanted to. Whoever else was there, even if there were lots of other people who could enforce. Now, so that's the conveyance. I think probably I should add in at this point 2 factual references, one to deal with the governors as they now are, and 2 to deal with the draft deed of modification. The governors are now the Whitgift Foundation. If you take up the supplemental bundle and you go to, I think it's near the back of the supplemental bundle, it's page 139. Now, I'm dwelling on this a bit because we seek to get some assistance by way of construction here from the nature of the people who are selling off this land and the people who have the ongoing primary right where the word governors is used. So we're talking about a charity and what might have been envisaged by a charity. I think Melanie Friend takes objection to categorisation of charities with being rather less in the same category as a rather less reputable type of developers. But obviously, he will be contending that charities did take to themselves this very wide power. Now, the Charities Act has recitals at page 140, so we know from first recital that it goes back to 1596 when Archbishop Whitgift founded a hospital in Croydon, and there were some statutes that were drawn up, and there was a hospital and a school building and a house for the schoolmaster. And then para 2, or recital 2, in 1856, the Court of Chancery promulgated a scheme for the administration of the foundation and the appointment of governors, and a scheme under the Endowed Schools Act. All that obviously precedes the conveyances we're concerned with, so that's all part of the background. And then recital 6, the governing body of the educational foundation, hereinafter referred to as the governors, by virtue of the 1953 scheme, the body of trustees having the administration and management of the almshouse charity. And then the actual provision by which we now find there's the body corporate is section 3 on page 142. The persons who shall on the appointed day and all other persons who shall from time to time hereafter constitute the governors are hereby constituted a body corporate by the name of the Whitgift Foundation with perpetual succession and a common seal. So that's how that foundation comes to be material. Now, the case is about the ability, if it exists, of the Whitgift Foundation to license the demolition of this house. And there's a draft deed modification which is in the core bundle at page 104. And this is, I think, here, yes.
Is there any prohibition against demolishing a house? I mean, if you should want to buy a house and then just simply demolish it and use the land for croquet.
I don't think there's a prohibition on demolition, there's a provision.
No, there's the 3'6" rule. But,
Well, yes, there's no building shall, going back to 7, no building shall be erected except a detached dwelling house, etc.
yes, so it's not. You're not told that you have to upkeep your your property. I mean, you mustn't cause a nuisance, but what's objectionable here is putting up something else, not taking something down.
Yes, I mean you pose an interesting issue. If you look at the end of 8, the purchaser shall build strictly in accordance with the approved plans. So what we've got here is we've got land being sold off without there being dwellings.
Yeah.
And the dwellings aren't, although they're all detached, they're not all looking the same, because different buyers, they bought their land and then presumably there was somebody who went around building houses. The purchaser shall build strictly in accordance with the approved plans and shall not make any alterations or additions to the property. So whether an alteration embraces the demolition, or add any further buildings without submitting plans and elevations of such alterations or additions and obtaining the approval of the governors.
Right.
So probably the only provision that might bite
Alteration.
Yes, would be if it was an alteration. Now, there was a certain amount of, put it politely, sparring correspondence in which the defendant solicitors pre-action weren't actually telling us what they were planning to do, and indeed were doing everything possible to fob us off so we didn't litigate. And eventually, after months went by, we did litigate, and then we discover what their position is, because we then get the defence and counterclaim, which is at 99, and annexed to it is the draft deeded modification, which begins at page 104, and the material portion is in clause 1. They've blocked out, so we've no idea what the money is. In consideration of the agreement and of the sum of whatever paid by the owner to the foundation, and of the covenants by the owner hereinafter contained, the foundation, so far as it is able, hereby releases the owner and successors from the obligations under the covenants and stipulations contained in the conveyance, etc. So there's no kind of warranty here by the Whitgift Foundation that if you pay them money, that in fact it will do any good. Now, the defendants are quite wised up to this, so they haven't actually paid across the money, particularly because obviously we've litigated against them, and so they want comfort that paying this X pounds, whatever it is, will actually mean that the release actually works. The judge asked my learned friend Mr. Fane in the lower court what the position was about the charity, the Whitgift Foundation, and was told that the Whitgift Foundation were aware of the litigation, but otherwise they plainly are not taking any step in relation to this. So they are sitting on the fence, or taking a backseat, whatever phrase you want to use, leaving it up to the courts to deliberate and decide this position without rendering any assistance to the court. You might think that if there actually was material that would help them, that they would have wanted to come forward and present it, but they have chosen not to do so. So that's the deed of modification that was provided to us with the pleading, and that's what they want. That's what the defendants want to be able to enter into on the basis that it will actually work. So those are two, as it were, postscripts to the conveyance. I now come on to part 3 of what I want to say, which are submissions. I've got a preliminary point, which I'm going to make. I made it to the Deputy Master, and he wasn't overly impressed. It's to do with the matrix, the fact at the time the conveyances were entered into. It's something that's in my client's statement, and you have to find that in the supplemental bundle. So you go into the supplemental bundle at page 27. What happened here, just to set the scene, is that after pleadings came in, the defendants sought reverse summary judgment, so they wanted to knock us out, and so they put in, first of all, a solicitor's statement, Mr. Warner-Reed, and then Mr. Mackenzie then came back, he's the claimant, beginning at page 20 in the supplemental bundle, with various points. The material one for these purposes is paragraph 33 on page 27, because Mr. Warner-Reed referred to his client's construction as being in accordance with commercial common sense, and so that was rebutted by my client at paragraph 33. And you'll see what he says. I wish to draw attention to the factual position in 1947, when the conveyances the subject of this case were entered into. Town and Planning Act of 1947 didn't become law until July 1948. The land the subject of this case, including my property, was subject to the County Borough of Croydon Town Planning Scheme 1929, with similar schemes in place for neighbouring areas. The land was allotted by the vendor or the governors, and covenants were written to comply with the provisions of the scheme, which included provision for not more than 8 houses an acre. And then he then refers to a letter which we have got in this bundle at page 68, which is on the note paper of the County Borough of Croydon and is written by the town clerk, and has got a reference to this 1929 order in the heading. I am to inform you that this property is zoned in the town planning scheme for the erection of dwelling house at the rate of not exceeding 8 to the acre, other buildings being permitted only with the consent of the council under the scheme. And so Mr. Mackenzie in paragraph 33 goes on after referring to that letter, and he says, the original purchaser of a lot would have needed the security embodied in the covenants that other parties couldn't build at a higher density, or otherwise they may find themselves unable to build on their plot. It's clear to me the intention of paragraph 11 was to allow the vendor to dispose of future plots or parcels unfettered by the restrictions they'd already imposed, but not to change the covenants on those plots which they had already sold. I don't understand how the governors could legitimately sell at a price land with certain benefits, and then after the sale has taken place, take away one of those benefits, particularly the valuable benefit concerned with density. So that's more in the nature of a submission, that point there, although it has some weight as a submission, that people are paying money to get certain rights, and you would know, because the law about restrictive covenants was well known even at the time of these conveyances. So lawyers would be able to...
Mr. Mackenzie refers to the original purchaser. The very original purchaser certainly wouldn't have had any of this. I mean, when the charity first sold off a plot, there would be no question of that purchaser getting the benefit of any restriction on future building or sales.
Are we now talking about the order of...
I mean, we happen to have 2 sales here, 444 and 432.
Yeah.
I dare say 444 wasn't the first one. I don't know. Maybe it was. But at any rate, when the original sale was made, the original purchaser will not have had the benefit of anything.
Well, I think what Mr. Mackenzie's doing is he's saying certainly the 1929 order would have been around.
Yes.
And so what he's saying is the 1929 order had development of dwelling houses at the rate not exceeding 8 to the acre.
Yes.
So a way of controlling what went up would have been by some of the covenants that we've got in these conveyances.
And fine, the charity could control in that way, but the very first purchaser would have had no control at all. The very first purchaser wouldn't have had the benefit of any
You're quite
covenant.
correct, yes. So it isn't to do with the order, you're quite right. The first person has got nobody to enforce against.
And he has to run the risk that the charity will allow dozens of properties to be built on neighbouring land.
Yeah. Yes, well, that's one of the curiosities. I'm not sure curiosity is the right word, but that's one of the consequences of where restrictive covenants run by the principle of annexation.
If you choose to negate a building scheme.
Sorry, my lord.
I was going to say, do we have the conveyance of 432?
We do.
Your client's predecessor.
We do.
Where do we find that?
Wait a minute, we've got... Yes. It's supplemental bundle, page 103.
Thank you. Does it contain any express assignment of the benefit of the covenants?
I don't think it does, my lord, because it's not something we're relying on. We're relying on the
No, but Mr. Mackenzie, the evidence you've read us, has Mr. Mackenzie referring to the governors selling off the plot with the benefit of a particular right?
Yes.
And I just wonder whether it was relevant, whether they had expressly assigned with the conveyance the benefit of the covenants entered into by previous purchasers, such as 444, or whether you're only basing your right to the benefit on annexation. And I think the answer is it's the latter.
It is, my lord.
And as I read the pleadings, that's statutory annexation under Section 78 of the Law of Property Act.
Yes.
The effect of Section 78 in effecting universal annexation to post-1925 covenants was not really uncovered, if I remember rightly, until Federated Homes, which was Mr. Justice Brightman in 1974.
Yes. I haven't got Federated Homes in the...
But it was some time...
I think your Lordship's right. It's late, beyond the date of the conveyances we're concerned with.
So I wonder how accurate it is to say that in 1947, when the governors sold a plot, they did so with the benefit of particular rights. So it's not obvious to me, if they haven't expressly assigned the benefit of covenants, that at the time it would have been understood that the purchasers, such as the first purchaser 432, would get the benefit by annexation under Section 78 of covenants already entered into.
Well, my lord, it's an interesting proposition. I certainly wouldn't wish to accept the implication that it wasn't until Federated Homes that the annexation principle became known. It would be necessary probably to either look back through the history of the cases, possibly even find, as one sometimes does, go to one of the contemporaneous books to see what, if anything, is said about it. I think we're getting into this because of Mr. Mackenzie's comment about the 1929 planning order.
The effect of Mr. Mackenzie's evidence was, look, at the time, this bit of Croydon was subject to zoning under which there was a maximum of 8 houses per acre, and he's almost accusing the governors of going back on a deal they did in 1947, under which you bought a plot on the understanding that there would be no more than one dwelling on plots previously sold, and that it would have been surprising for the governors to retain the right to dispense with that. But that is, may not be dependent on, but it's certainly framed as, when my predecessor bought the plot, he bought the plot with the benefit of this stipulation. And
Yeah.
I'm just testing whether that was something that was actually what was going on in 1947.
Right. Well, there's two levels to your Lordship's point. One is I'm not impressed by the reference to the 1929 order or anything building on that. And then there's the separate point, which is a far more fundamental one, which is what somebody would appreciate when they're buying
Yes.
conveyances in an order, and what they would expect. The principle of restrictive covenants, of course, would have predated that by many, many decades. It would only be whether somebody would have worked out for themselves whether they would be amongst those people who had the right to enforce covenants.
I'm relying on my memory here. And I think that before Federated Homes, there was a view that in order to annex the benefit of a covenant to each part of an estate so that it went automatically to subsequent purchasers.
Yeah.
The traditional way of doing it was by using the word be annexed to, and so that the benefit of the covenant shall be annexed to and go with.
Yeah.
So certainly if you don't have those words in the conveyance of 444, which I don't think you do, a subsequent purchaser might very well not even know anything about the terms on which the previous conveyances had been sold, had been made, but would not, from the form of his own conveyance, expect necessarily there to have been any annexation. Now, of course, we now know, as a result of federated homes, that since 1925 there had been annexation.
Yeah.
It may not have been at all obvious to anybody at the time. That's the only point I'm making.
Yes, yes. Well, there are a number of possibilities. There's an extreme one, which is whereby somebody, if he asks his lawyer, would be told, no, you have no right to enforce. Or maybe you do have a right, and of course, certainly post-federated homes, you definitely do have a right. I'm not in a position to be able to say, and indeed, to a degree, this is supposition in any event, because once you've had the forgetting about the initial purchaser, someone down the road, well, I suppose it is only impertinent to the original purchaser, because it's what the original purchaser thinks they're getting.
Yes.
By this, I mean, they're getting a plot within an area of land that has itself been divided into plots. So if they didn't look at any legal documents, their assumption would be, oh well, all these other plots which have got dwelling houses, the dwelling houses will stay there. And a typical conveyancer, like a typical buyer, probably would go no further than that. Would say, well, here I am, I'm buying a dwelling house, all the other properties are dwelling houses, that would be my expectation. And indeed, forgetting about the law just for one moment, that is how things have stayed in this vicinity all the way through. In fact, there was another page in the report which I didn't take you to, which I perhaps should have done, which is...
Just before you do, and going off at a tangent, Mr. Warwick, I see on the page following the letter from the council, we get a plan. Do you happen to know, just really out of curiosity, is this a plan of the totality of the estate, or is the estate some smaller part of it?
What page are you on?
Sorry, 69 of the bundle.
I assume that was where the zoning...
It's the zoning, is it?
It says Croydon East Town Planning Scheme.
Well, that makes sense, yes.
But I know you're going to go back to the planning document, but I was wondering what this preliminary point is really going to, because it didn't impress the deputy master, as you frankly said, and I think from looking at the bundle, it hasn't featured since, and didn't feature, at least in the judgment below.
Yeah.
It doesn't feature in your skeleton argument.
Yeah.
And so, very happy to entertain it, but having entertained it, I'm not quite sure how it can do you any good
Well, my lord,
at this point, unless it's a pure point of law.
my lord, sometimes as an advocate, particularly where there are a number of people who are affected by the arguments, it's perhaps important that the matter is the subject of at least brief debate.
Yes.
For the benefit of not even just my client, but others. There are, as I already told you, quite a lot of people who are affected by this. And if I didn't make the point, then it would be said, why didn't you do this? Why didn't you refer to this letter?
At any rate, Mr. Warwick, I don't think you need to worry about my tangent, because my lord is obviously right. This has nothing to do with the charities estate, it's to do with the zoning, so don't worry about it.
Yes.
Do you happen to know, looking at that plan, roughly where on the plan the plots you're talking about are, where the Governor's Fox Farm estate was?
Well, I can take brief instructions, my lord, because there's someone here, I think, who can help with that. Perhaps you can put a cross on here. No, it's the big plan. It's
It is page 69 of the bundle, or indeed if it could be done on page 7, the following pages.
No, but what is this one here?
Yeah, this is a more zoomed in version of that.
All right. So it's part of this green.
Got the orange dot there.
Oh, is it? Ah, so I hadn't spotted. If your lordship looks on page 69, you will see over on the left-hand side, there's a small orange dot close to the blue boundary.
That is the 444, is it?
That's 432.
432.
432.
Yes, because 444 is just further up on a corner.
That's very helpful. Thank
432
you.
is half a dozen houses down.
Yeah.
I follow. And it really doesn't matter. In terms of the overall estate, we don't know where that was. Obviously, it is known where it was, if you take instructions from behind you.
There is a. I think there is a plan somewhere in the supplementary bundle
Is there?
of at least part of the Fox Farm estate. Page 86.
Yes.
I see.
Yes. And then what we probably need to know is how 86 fits in with the bigger. Maybe you do or don't need to know that.
And the truth is, we don't need to know, Mr. Warwick, but looking at 86, I would guess that this is after some of the properties have been sold off. But I may be wrong about that. In the sense that one might have thought that where you see properties intruding into the red-edged area, you might guess that they were once part of the estate and had gone out of it. But I don't know. I see actually there's nodding from behind you, so I dare say that is correct, that the properties shown on the edge of the red area were once part of the estate and have been sold out of it.
Yeah. In perhaps deference to my lack of knowledge on this topic, since it was never part of our case that we had a scheme, I've never had to investigate the history in that respect.
I'm afraid it's merely idle curiosity rather than
Well,
thinking
no,
that it actually matters.
Sometimes these things can be important. I made a statement about 3 minutes ago when I was talking about the dwelling houses, just to support what I said about them even now being nearly all dwelling houses. In the report that I took you to in the core bundle, I didn't take you on to page 130. About 2/3 of the way down, there's a heading, Townscape and Visual Impact, 8.7. This is a residential area which comprises mostly detached dwelling houses. The buildings are mostly 2-storey with pitched roof, although it's noted that owing to land levels, something is...
What page are you reading?
Page 130, Lord. Supplemental bundle. Sorry, core bundle.
Okay.
So, it may or may not be dangerous to proceed on the basis of suppositions, but lots of people since the 1930s have been buying these plots with detached dwelling houses, and they have remained such until very recently. And my learned friend wants to say, so I will be dealing with it when I get to his skeleton argument, that there have been a couple of other consents that have been given. You will see when we look at the evidence that they're very different from the type of thing we've got here. They're what you might call tiny changes. The line is being drawn here because this is knocking down a house and putting up a block of 9 flats. So that's why the issue becomes really important.
Right, that's the preliminary point, is it?
That was my preliminary point, and I couched it deliberately as preliminary because the reasons I've explained. I made it to the Deputy Master, so it's still there. Now, we say that the consequences of the defendant's construction of paragraph 11 could result in a radical change to the user of a plot, and that would be contrary to 1, common sense, and 2, authority. It's in common sense to a degree I've already made in reading out some of the paragraphs in the conveyance. I, for example, flagged up paragraph 5 and referred to the users there, the gasworks, the hospital for contagious diseases, etc. And it must, I think, follow from the wide construction that the defendants adopt, that they are saying that, forgetting about planning, that, and of course planning seems to have not been really around at the time of this conveyance. Was it really envisaged that the, well, we know planning wasn't really around, that the charity would come along and create this careful structure, but then create a system whereby even the plots they've sold off, they can then change the structure and get rid of them all, because they're the only ones who could be enforcing positive covenants. And so they could simply say, under paragraph 11, fine, we will get rid of the lot. And we say that is not common sense. But the second, legal authority, is touching and expanding on a comment I made earlier on, which is that this is derogation from grant stroke specific provisions somehow being overridden by a general provision. And I wanted to canter through, I think, 4 cases. I won't take too long, but they are illustrative of one or other of those propositions. Because if I'm inviting you, as I am, to give the language of paragraph 11, or rather give the specific covenants primacy over paragraph 11, or over bits of paragraph 11, then there needs to be some principles to be deployed.
Just to be clear, the grant in favour of your client is the conveyance we've looked at in 432.
Yes.
And you say that for the charity to allow building on 444 would derogate from the grant of 432.
Yes. But my submission is far wider than this, because I'm looking, regardless of the position, 432 gives me the locus to bring the claim. But it's the general proposition that when the conveyance of 444 is put together and the charity takes and takes all these covenants from the buyer and then has paragraph 11, is it envisaged by the charity, objectively, not subjectively, that all these covenants don't actually matter, including some covenants which are absolute and some covenants which are qualified, because it can come along and say, under paragraph 11, I can get rid of them all.
And I see that in terms of general arguments on construction, specifically in relation to derogation from grant. It would have to be a derogation from the grant of 432, wouldn't it?
Well, it's surely legitimate under derogation from grant, because in these cases sometimes they're almost viewed interchangeably, although I appreciate they're different doctrines, that you've got to have a grant, but when we get to the first conveyance, before we've even got to any of these conveyances, the charity draw up this schedule with specific covenants, and then they have this other provision at the end. So it's necessary to, I suppose, as a process of construction, say what was envisaged here, because that indeed is, you're having to look back at the conveyance at the time it was entered into, and that the conveyance of 444 is presumably not the first one; it would have been earlier ones.
Can we go back to the very first one? I agree,
Yeah.
It's not likely to be 444, but the
Yeah.
very first one. So the charity sells the very first plot to somebody who buys the plot, has restrictive covenants imposed on him, and then there's paragraph 11 included in the schedule. So at that stage, whatever paragraph 11 means, it can't derogate from the grant to that original purchaser, can it?
No, I
because
agree.
all he's getting is
Yeah,
the plot subject to covenants.
yeah,
So derogation from grant can't help on that original sale.
yeah.
And if, I mean, extending it a bit further to construction, it wasn't contrary to the interests of the original purchaser for paragraph 11 to have the meaning that the defendants give it.
Well, because there is nobody else out there, as we...
They have the benefit of no restrictive covenants at all.
Yes.
On the defendant's construction, they had the option of getting a release from the covenants that they were giving, either from all the other owners or from the governors. Well, that must have put them in a better position, or at least a no worse position than they would have been in but for paragraph 11. Because if you didn't have paragraph 11, they had to get the consents of all the future purchasers. With paragraph 11, they could get the consents of the future purchasers or the governors. So that must have been to the original purchaser's benefit.
Yes, this concept, which I think was raised by the judge, probably by the judge on the basis of submissions that only friend made, is interesting. But whether this is something that would have actually occurred to anyone at the time.
I mean, I follow that, but just anticipating where you're going, if we focus on that original purchase...
Should we call that lot 1?
Lot 1. If we focus on lot 1, derogation from grant can't come into it, because even the defendant's construction can't on any view derogate from grant. If anything, it was to the original purchaser's benefit. And again, arguments about, which I think the master refers to, about sort of construing contra proferentum or whatever.
Yeah.
Well, actually, it was in the interests of the purchaser as well as potentially the governors to have paragraph 11 in the form that the defendant suggests. So that doesn't really help.
Yes. What your lordship's doing is you're focusing on the notional conveyance of plot 1.
Which there will have been.
Yes, there will have been, but of course, without wishing to be difficult, we aren't concerned with the conveyance of plot 1. We're concerned with a subsequent plot.
So just going on to plot 2.
Yeah.
When plot 2 is sold, plot 2 gets the benefit of the covenants given in relation to plot 1, subject to whatever paragraph 11 means. But plainly, the meaning of paragraph 11, so far as the original purchaser was concerned, has already been fixed.
Yes. Well, you say fixed. I mean, it wouldn't have been. Who knows? Nothing is fixed.
Doesn't this point arise from my lord's question? So, the clause 11 must mean the same for lots 1, 2, 51, 52, 101, 102, however many lots there were.
Yeah.
It's going to mean the same between them, although it may have differing values.
Well, my lord,
because of the queue system that operates.
Curiously not, because it doesn't follow, as I think I've got a reference somewhere, which I was coming back to, the Reason Peters line of authorities. You can have identical documents entered into at different times, and yet the construction is different.
I thought that was to do with two different cases, transferring a finding made in relation to a form of words used in one case into a different case.
Yes.
Well, this is the same document.
Well, it would be the same. It would be a document that would have the same terms on it, presumably not exactly the same terms, because there would be different.
Well, so you're throwing up the possibility that clause 11 might mean something different for plot 1, plot 10, plot 20, plot 30, plot 50, whatever it is, and that we should contemplate.
Well, I'm just not wishing to be boxed in, to be very polite. Sometimes you find that there's a line of argument that seems persuasive, but in fact it isn't always the case. I mean, if I was to take plot 1 and go right to the very end, then the setup on the estate would be very different, because you would have had all the other plots sold off, houses all built, presumably all single detached dwelling houses on all the other plots. So the background would be very different, the matrix of fact. So you might have the same words, but somebody would say, well, does that mean that the meaning to be given to those words is exactly the
Right,
same.
so if you take plot 1 and you're considering the first house being built in a greenfield area,
Yeah,
and then one goes to plot 101 being the last house to be built on a housing estate, effectively,
yeah,
they might mean something different because of the different context.
yes, yes,
All right, I understand.
yes. But I think we got into this interesting dialogue because of the doctrine of derogation from grant, and it was being put to me that derogation from grant, you obviously look at what I think it's being put to me. You look at the circumstances at the time of the grant. The problem with that is that derogation from grant has been given a wider meaning, because the argument that I think my Lord Justice Newey was putting to me is that you can't look at circumstances that postdate the making of the agreement, or the making of the. We're going to look at Johnston's case in a moment, because the argument that was being advanced in Johnston's case is there was a lease of a large wall that had been used to put up advertising hoardings, and the tenant and the landlord fell out, and the landlord then acquired another piece of land not very far from the wall and put up his own hoarding, completely blocking visual access to the wall. And the argument that was being advanced by, and it's said by Lord Justice Nichols to be very cogent argument, is you can't succeed under derogation from grant, because at the time of the grant, the landlord didn't own this extra piece of land. So he deliberately couches the doctrine of derogation from grant in a very wide way, so that he has to, in order to catch the facts of that case. But and maybe now is the time to look at Johnston case, because that was the first of my little line of cases I was going to look at. If we go back to the...
Just tell us what the 4 cases are before you take us.
I will, I'll tell you. Johnston at tab 2,
Yep.
Esso at tab 4, Cartree at tab 7, and Amberley at tab 8. Now, Johnston at tab 2, I've more or less told you what the facts are. If you're on page 14, you've got a head note, and you've got it might be useful to actually look at the head note, because that flags up what's going on. Derogation from grant, scope of criticism, comprehensive and important review of all parties. Application in the case of interference with rights reserved to use the flank wall of a property for advertising purposes. Appeal from the county court judge in favour of the claim the rights have been frustrated. Respondent in the present appeal was entitled to a 99-year lease of the property. The appellant's company with 2 shareholder directors had in the course of time acquired the freehold and a sublease of the property, leaving the respondent with the immediate leasehold interest. The flank wall, with its advertising hoardings, faced an open site which became a car park and eventually became vested in the appellant company's shareholders. For a long time, no difficulties arose about access from the site to the hoardings, and at some stage a passageway was constructed between the wall and the remainder of the site. Later, the appellant company objected to ladders being placed on the site at a point beyond the passageway for safety in gaining access. When a working platform was placed above the passageway to avoid trespassing on the site, the appellant company retaliated by erecting a massive hoarding close to the passageway, thereby obscuring any advertisement on the flank wall. And then, if we pick up from, because the facts are quite complicated, but if you turn to page 17 of the bundle, and we're in the judgment of Lord Justice Nichols here. Yes, his name is at the top of page 15. I turn next to Mr. Tager's submissions. He was the bad guy, as it were, in relation to this, or acting for the bad guy. They are formidable. We have not been...
I'm sorry, where are we?
Sorry, my lord. Page 17 of the bundle.
Oh, thank you.
There's a big red line.
The marked passage, thank you.
Yes. Turn next to Mr. Tager's submissions on the law. They're formidable. We haven't been referred to any case in which it's been decided or even suggested that the non-derogation from grant principle can apply in respect of activities of the grantor on neighbouring lands subsequently acquired by him. Despite this, a rigid, inflexible limitation excluding such activities by a grantor from the scope of the principle in all circumstances is capable of producing such unattractive results that, given the rationale underlying the principle, I'm emboldened to consider whether indeed there is any such overriding limitation. And you've probably seen this passage before because it's often cited. The expression derogation from grant conjures up images of parchment and sealing wax, copperplate handwriting and fusty title deeds, but the principle is not based on ancient technicality of real property. And then there's a reference from Lord Justice Younger. Principle in legal maxim, a rule of common honesty, was imposed in the interest of fair dealing. A grantor having given a thing with one hand, as Lord Justice Bowen put it in Birmingham Dudley, is not to take away the means of enjoying it with the other. If A lets a plot of land to B, as Lord Lorburn phrases it in Littleton Times, he may not act so as to frustrate the purpose for which the contemplation of both parties the land was hired. The rule is clear, the difficulty is always in its application. As one would expect, the principle applies to all forms of grants, and then they refer to the British Leyland case. And then if I go down to just above M, it's also well established the principle is not confined to cases of the implication of an easement. For example, Aldin, Mr. Justice Sterling applied the principle to protect the access of air to sheds used for drying timber, even though the law doesn't recognise a right-of-way of easement for the access of air except where the right is enjoyed through a definite aperture. And then something that's quite important, Mr. Justice Parker in Brown and Flower regarded the implied obligation in such cases as analogous to that which arises under restrictive covenant. In the Gary and Wade, the law is expressed that in truth the doctrine is an independent rule of law. The approach was approved by Lord Denning in Malton and City of Westminster, and he said the broad principle thus: if one man agrees to confer a particular benefit on another, he mustn't do anything which substantially deprives the other of the enjoyment of that benefit, because that would be to take away with one hand what is given with the other. Now, if one focuses on those very general words, which is what I'm doing for the purposes of derogation from grant, then I don't, as I perceive it, meet a brick wall, sorry to mix my metaphors, by the examples that we were talking about.
Can I just try clarifying it a moment again? Lot 1.
Yeah.
Whatever the governors did or didn't allow on the neighbouring properties, couldn't or could it derogate from the grant to the purchaser of Lot 1?
The answer is it may be, because if we're looking just at the principle of derogation from grant, you'll see in some of the other cases, although sometimes it's expressed as a principle, you've got these very specific obligations, and then the charity comes along and wants to do something else.
But all the charity has done, so far as Lot 1 is concerned, is say, look, we'll sell you this plot, and we want you to give some promises.
Yes.
So if they, on the neighbouring plot, allowed numerous flats to be put up, that wouldn't, on the face of it, be a derogation from the grant in favour of the purchaser of Lot 1?
Well, the purpose of the conveyance, conveying the plot, is to give a plot on which is to be built a single detached dwelling house.
Well, that's not from the purchaser's point of view. He just wants the plot. He may be subject to covenants, but that's not what he's concerned about. He'd like the maximum possible freedom.
Yeah, but he knows that under the conveyance he's acquiring it subject to these obligations,
yes,
including the obligations. So if and we're now doing a different scenario from our case, but if the first owner 1 of plot 1, buying it with the expectation that he will get this plot and it's going to be strictly controlled what he can put up there, and he then finds that the seller has completely done a volte-face and has decided instead of this going to be an area laid out for all these single detached dwelling houses, it's going to be an industrial zone. Now, obviously the facts in a real case would have to be investigated, but I think your lordship is putting to me that in that scenario the buyer of plot 1 would have no redress.
Yes. I mean, in order to have redress, wouldn't the buyer have to have been the beneficiary of a covenant coming from the original vendor saying that they were going to impose similar disciplines on subsequent
Well, one of the attractions.
purchases
Yes, sorry, my lord.
in a case that wasn't an estate.
Yeah, I mean, one of the attractions of derogation from grant is that, as we've seen, it's a very flexible remedy. So the owner of plot 1 would say, my grant is I'm being granted a plot of land and I can only do very limited things to that plot of land. And I've paid a price for this. I mean, it may not seem very much to us, but presumably it was a lot of money then. I'm paying a price. And I now find that if I do, the only thing I can do is put up this plot, the only thing that I'm allowed to do is put up this nice detached dwelling house. It would be ridiculous for me to do so because they're going to put in gasworks all round.
I mean, I can see there might be an extreme case where what was done on the neighbouring land really did substantially deprive the first purchaser of the benefit of his purchase of a plot for a residential house. But I can't at the moment see how derogation from grant could affect the charity's ability to permit a block of flats to be put up next door.
Is that a sort of an evaluative point?
Well, it is sort of. I mean, I can't see how that could substantially deprive the original purchaser of the benefit of his purchase, because what he's purchased is the plot on which he can build a house. He can still do that, and the charity hasn't given any promises in relation to what it will do with neighbouring land.
Well, what we're, with the backdrop to all of that is what is the scope of the charity's rights under paragraph 11. It is, and the learned friend doesn't want to shift from his position. He probably can't shift from his position because it erodes the foundation. His position is, regardless of the timing, forever and ever, we can do what we like. Now, there are doctrines around that can control the exercise of powers, either because of the use of the words or because of, as I say, derogation grant. It may be you're not persuaded, and indeed in one of these 4 cases, the judge said, well, here's derogation from grant, but I don't think it's really derogation from grant. I think it's more a case that the general words give way to the specific provisions, and you can't. There's one of the cases that's at any time, and at any time you would have thought means at any time, but the Court of Appeal said no, it doesn't. No, it doesn't mean this particular year. It may mean other years. So general words will give way, or can give way to the specific, and what I'm all about is that the general words in paragraph 11 aren't to be given the enormously wide construction that they do.
Can I ask you something else?
Yeah.
We know, as you showed us from the Whitgift case, that which covenants you get the benefit of depends on where in the order you come. So if you take somebody, not lot 1, but lot 50, who's roughly halfway through the sale of the estate, so he's got the benefit of the previous 49 purchasers' covenants, but there's another 50 purchasers subsequent to him, and he doesn't have their benefit of their covenants. And let's assume that he can see on the ground that this whole estate is being laid out with single detached dwelling houses, which indeed is what the evidence is what actually happened. But at the time that he buys, what he sees is there's 50 houses already built or in the process of being built, and his empty plot, and another 50 plots not yet developed.
Yeah.
Now, I understand entirely why such a purchaser might assume that the other 50 plots would also have detached dwelling houses, and that was the way the charity was going to sell off its estate.
Yeah.
All like that. Partly because of the local plan and the zoning, and partly because you could see the pattern, and partly because that's what his covenant says. When you look at his conveyance, the first part of Clause 11, which we haven't really focused on at all, undoubtedly says the governors do reserve the right to sell off subsequent plots subject to different or no stipulations. So when you're halfway through the process, although you may hope and expect, and you may be right, that the likelihood is the rest of the estate will also be detached dwelling houses, you don't have any legal right to complain if the governors then sell off the rest of the estate for much denser housing. There may have been changes to the local zoning. There may have been changes to the economics. They may have had an offer which, being charity trustees, they really couldn't pass up, to sell not for detached dwelling houses but for blocks of flats. The purchaser of lot 50, halfway through, has quite plainly, by the first part of clause 11, no right to prevent the governors from doing that or to complain if they do that. So why should he have, which is the burden of your submission, any legal right to complain if some years down the line purchasers of lots 1 to 49, the benefit of whose governance he does have under section 78, the governors are persuaded that it might be appropriate to relax those?
Yeah. Well, my lord,
I can see entirely that if there was a building scheme, it would be different, because the whole basis of a building scheme is the first purchaser enters on the basis that everybody will be subject to the same rules.
yeah.
But we're not in that position. You know you don't have a right to stop subsequent lots from being developed on different rules. So why should you have a right to stop previous lots being changed?
Well, the fact that that the right you gain is not perfect because you've got half developed and half not developed isn't a reason then to say that you shouldn't have the rights over the part over those the half that have already been sold off. So you're giving him, all right, half is better than nothing at all.
Yes, so he'd have a right to object to the glue factory on his left-hand side, but not on his right-hand side, depending upon what order the plots have been sold off in.
Yes. Yeah. So if we're in the middle, your lordship is saying, well, if I have to concede the middle, then I've got to concede the lot. I'm saying,
No, I'm not saying that. I'm saying the thrust of your submission under non-derogation from grant is that somebody buys on the basis they're getting a plot in an estate of single houses.
yeah,
And that it is a derogation from that if you construe the second bit of clause 11 as allowing the governors to allow a departure from that. That's your submission.
yeah,
But it's not. The only point I was making was you can't say when you buy a plot halfway through the development, what I'm buying is a plot on an estate where I have a right to expect that all the lots will be subject to this, because we know that the first part of clause 11 takes that right away, doesn't give you that right. The argument you're facing, as I understand it, is that's what the first part of clause 11 does. What the second part of clause 11 does is it also allows the governors to vary stipulations which have already been entered into. And I think the argument accepted by Mr. Justice Miles was the two bits of clause 11 should be treated as doing two different things, whereas I think the Deputy Master, very experienced Deputy Master, was persuaded by you that really they're doing the same thing in slightly different ways.
Well, there were obviously a number of arguments before him, and there will be a number of arguments deployed. The emphasis will probably vary, my emphasis, and indeed probably Bernie Friend's emphasis. My lord, the fact that in this buyer of plot 50 can't invoke derogation from grant as regards plots yet to be sold off, isn't a reason why he can't invoke derogation from grant in relation to those which have already been sold. That's the grant.
Yep. Now I understand the way you put it, yes.
Sorry, just to be clear, I was taxing you on lot 1 a moment ago. What's different with lot 50 is not the terms of the conveyance, but the fact that there is implied annexation such that you get the benefit of the earlier covenants.
Yeah.
So, supposing for the sake of argument that the purchaser of lot 1 couldn't invoke derogation from grant to stop a block of flats being put up next door, which there would be derogation would depend on the annexation,
Yes.
even though that's not referred to in the conveyance. But you say impliedly you're
But
getting...
it's common ground.
Yes, no, quite. So impliedly you are being granted not merely the plot, but the benefit of the covenants.
Yes. And if I'm being given the benefit of the covenant in relation to the plots that have already been sold, then something shouldn't be done that takes that away. Or of course, derogation from grant is a flexible doctrine, so it doesn't follow that there might be some small thing that the charity can do. So unlike my learned friend who wants the lot, you know, there are intermediate positions that I can advance on behalf of my client, which will still stop the demolition of the house.
So you might have a construction, might you, where the governors could legitimately waive the stipulation but it be used as one dwelling house by allowing an existing house, without changing its appearance, to be divided into two flats.
Well, I was going to come up with a slightly different example. I was going to pick up Lord Justice Peter Jackson's example, where he was talking about demolishing the house. But now, you know, people do, particularly rich people, have this notion, I'll knock this house down and I'll build another house, but in more modern vogue. So that, let's assume that when we were talking about the language, that it's not permitted under those covenants. But nonetheless, the charity comes along and says, well, whatever alteration means, this isn't an alteration, it's out with that covenant, but I'm going to allow you, the owner of that plot, to demolish the house and put up another detached dwelling house. Now, when you then look, so you're then construing paragraph 11, and if challenged, then the charity would say, we're allowed to do this under paragraph 11. It may be giving some, it's because paragraph 11's got the word alteration in it, I think, hasn't it? Let me make sure I...
Departure.
It's a departure, because the words are not the same. It's been assumed, and indeed it was assumed by the judge, that the second part completely covered every change you would want to make. It doesn't follow. You know, you could have a departure from the covenant, so that you can knock the house down and put up another house, another detached dwelling house. But you can't do these other things like a gasworks or other. So there's a number of things that could be done by the council, by the charity, that would not be actionable by the owner of the plot.
I'm just thinking about clause 8, which is what we've been touching upon now. It clearly provides for the first purchaser of a plot to produce some plans for the governor's approval of what is going to be put up. That's, I think, the first. I'm looking at 160.
Yes.
First half of clause 8 contemplates the first construction in the first half of that paragraph, and then goes on, and shall not make any alterations or additions or add any further buildings, again, without getting approval for that, submitting plans and getting approval. So the covenants don't achieve a situation whereby you get approval for the first building and it has to stand there till the end of time, because obviously people are going to want to develop buildings over long periods of time, or even short periods of time, as you say. And so that allows for something that might be indistinguishable from demolition and reconstruction. But you still have an ongoing relationship as a later purchaser with the governors, or whoever replaced them, where they're entitled to approve or not approve of the new building that you wish to put up. Is that not right?
Well, I think your lordship is giving meaning to the word departure. So departure doesn't mean wholesale removal of all the covenants. Departure means it is a word, and your lordships will construe it.
Well, I don't think I may have misspoken. If I did, I'm sorry, but I'm looking at clause 8.
Yes.
And the last 3-4 lines. which is once you've got permission to build strictly in accordance with the approved plans, you shall not make any alterations or additions or add any further buildings without submitting plans and elevations of such alterations or additions and obtaining approval. So the governors have quite a heavy hand over time
Yes.
in relation to these buildings, because they not only are entitled to have their approval
Yeah.
given in relation to the first building, but in relation to any subsequent versions of the building.
Yeah. I mean, if this was a lease, which it isn't, then you'd be looking at paragraph 11 as some kind of sweeper clause, and you construe it by reference to all the other clauses around. And you don't automatically assume, which was the judge's view, that the words have the widest possible meaning, and it's for me to show. This is when we look at the judgment, you'll see this is how he couched it. They have universally wide meaning, and it's for me to show why paragraph 11 doesn't work that way, whereas I prefer, obviously, the reverse way. So, Your Lordship was taking us to the end of paragraph 8 and referring again to alterations. Now, it's been rightly put, of course, since we're now dealing with freehold land going on forever. So, what's to happen if this house, say the house becomes unoccupiable and needs to be knocked down or something like that? I mean, we talked before about what does the word alterations mean. There might be circumstances in which the charity is convinced that it's appropriate to approve plans for a new house. Now, it may be that falls outside the scope of 8, but it may nonetheless be, it may be a departure from that, but it's something that they're allowed to do. But departure doesn't mean everything. That's part of what we're talking about here. Sorry, we got onto this,
I think that's my fault, Mr. Warwick. I think I diverted you from taking us through the cases.
No, well, no, you're rightly testing me on how does the principle, and both your lordships were testing me on the scope of the derogation from grant principle, and I riposte by saying it's a very wide principle. That doesn't mean to say that you've got to look at the context. If I then go on to the next case, which is the ESO case in tab 4, because one of these cases, they prefer construction rather than derogation. Anyway, this was a provision. So this is Mr. Justice Morbick, as he then was, page 46. And there was a provision in a petrol station licence permitting the review of payments by the licensee. And the question was, how was the provision to be approached? And if we look at there's some issues flagged up in paragraph 1 on page 47, but if we go on to page 57, then you'll see how construction and derogation comes in. Paragraph 47. The 5th schedule to the agreement set out the prices at which the licensee was to buy and sell fuel. The effect of its terms was that he was prevented from selling fuel at a price higher than the maximum retail price set by ESSO, and was obliged to buy fuel at a price which, if he did sell at ESSO's maximum retail price, provided him with a gross profit margin on each litre sold. The margin, known as the licence margin, was set by agreement at the commencement of the licence, but was subject to review by ESSO from time to time in accordance with the terms of the agreement. Then we've got the doctrine of derogation from grant was summarised by Lord Denning, and then there's that passage we've seen, and then it was later followed and applied in the Johnston case, which we've seen. And then Miss Gloucester submitted the principal grant in this case as the grant of the right to use the property to carry on the business of a service station, and the various payments which ESSO undertook to make to the licensee were incidental to that primary grant. The licence margin and operating cost allowance were both subject to variation by ESSO, and the agreement contains no guarantee as to the level of net profit that the licensee will be able to make. The licensee's obligation to comply with ESSO's operating standards will inevitably impose costs of various kinds, and no sensible distinction can be drawn between costs incurred in that way and costs incurred in operating a promotion, whatever their nature. The doctrine of derogation...
Would you like us to read 49?
Yeah, yes, I would. Thank you. Please do.
Yes.
So this is a case where the judge wasn't particularly attracted by using derogation from grant, but preferred, as you'll see from the final sentence, to ascertain what are primary clauses and what are subsidiary clauses. Now the next case is the Cartry case, which is at tab 7 on page 124. And this was all about performance-related bonus and whether the gentleman concerned was entitled to summary judgment on his claim for the bonus. And the matter went to the Court of Appeal, who decided that he was entitled to summary judgment. And the judgment was delivered by Lord Justice Jacob, who's paragraph 1 on page 125. And then if we first of all look at the language of the provision and then the analysis, the language of the provision is on page 126. And where the sidelining starts, it says performance-related bonus. And then there's a little box. And then the last line, paragraph 11, the above table is applicable to your 2008 bonus. The bank maintains the right to review or remove this formula-linked bonus arrangement at any time. And then, so when sued for the bonus, the bank said, oh well, those words at any time mean that we can reset the bonus. And the reasoning is on page 128, paragraph 36. And it's 36 to 38. Maybe I could invite your lordships to read those paragraphs.
Yes.
I don't think you need to read on 39. Just stop at 39.
Thank you. Yes.
Now that case and the reasoning therein was applied by this court in the Amberley case at tab 8. And if you look at the head note at the top of page 131, between B and C, so literally the byline, a term of a contract for residence in a care home that the level of fees was subject to review if costs increased did not, as a matter of construction, permit the fees to be increased unilaterally. And then we'll see how the holding comes up. But if you look in the holding at 1, although in general it was possible, subject to statutory safeguards, for parties to a contract to agree that one party should be able unilaterally to vary the terms of the contract to the detriment of the other, that would be an unusual provision and clear words would be required to achieve the result. That's still a pretty well-known proposition, but I wanted there to be some authority for it. And the reasoning in the judgment of, well, it's not clear whether it's Mr. Justice Akins or Lord Justice Akins. He's referred to as Lord Justice in the heading, and then in the judgment on 132. Anyway, he was delivering the judgment of the. I'll just check. Yes, he delivered his own judgment, but Lord Justice Richard and Lord Justice Mummery just simply agreed. So page 137, where the byline starts, construction of the contract terms. And again, to save my voice, or perhaps boring you, if you could kindly read the sidelined page goes to the end of paragraph 25.
Thank you. Lord Justice Akins.
Lord Justice Akins. Well, it certainly became Lord Justice Akins. I just don't know whether
He had been for 3 years by that time.
he... Right. So, and the passage that I would particularly emphasise is from F to at the end of H, just where I starts. So, and they refer to consistent with previous Court of Appeal authority. So, it's obviously a well-known proposition, but it's an important proposition because, in my respectful submission, when I come to the judgment, you'll see this is the reverse of the learned judge's view. Those are some cases, and I apologise if I've given you too many as it is, but they give you exemplars of different approaches. The separate point, which is I couched as a fallback point, but I don't mean that in any derogatory sense, is the torrential drafting argument. And it's the case in which that is most clearly set out is GLN in this bundle at tab 6. And you'll see, if you look at the head note on page 114, even before the head note, just the portion in italics, it was restrictive covenants in relation to a cinema and the interpretation of the restrictions preventing the use of the land as a cinema or for purposes ancillary thereto. So it was a user covenant in restrictive covenants, and then there were arguments in the usual way that Lord Justice Newberg, as he then was, he would often deal with a whole series of reasons for his conclusions, and at paragraph 30, page 119, there is a passage which is sidelined, which if I may, I would invite your lordships to read.
Thank you.
30 to 32.
Yes.
So my submissions, my primary submission is it's possible to give paragraph 11 a meaning whereby it doesn't in any way affect the past conveyances that have been entered into, like in our case 444. If I'm wrong about that, then you can give some meaning to the second portion of paragraph 11, but not the very wide meaning that the learned friend will be submitting. And or you don't have to give the second part of paragraph 11 any meaning, because you can regard this as a case where you've got torrential drafting.
Right, so you can either read it as meaning that it doesn't refer to past sales, or you can give it less meaning or no meaning at all.
Yes, the less meaning is where I was focusing in argument a little while ago, because it reserves the right to allow a departure from these. And departure, I don't want to get involved in semantics. Your lordships will have your own views about what words mean, but departure, we suggest, isn't wholesale removal in the way that the defendants contend.
So, sorry, what would could you just give an illustration of what a departure might mean?
Well, your lordship was helpfully taking us earlier back to that covenant in the one at
Number
clause 8 about the alterations or additions to the property, and we were having the debate about whether an alteration is actually a demolition and a rebuilding. So, if it's not demolition and rebuilding, then how is the charity going to be able to permit it? Well, it would have to be permitted, if anything, under paragraph 11, the second half, as a departure. But it would be that departure takes its colour from the other covenants that precede it.
Can I for a moment go back to lot 1? And I follow your point that things can potentially change over time. But going back to lot 1, what we see in these cases is the idea that a power conferred on one contracting party should be seen to have some kind of limitation, because otherwise it might work unfairly, irrationally, whatever, in relation to the other contracting party.
Yeah.
With lot 1, was there any such justification? I mean, the purchaser of lot 1 would probably want paragraph 11 to be as wide as possible, so that the governors could sanction anything. From his point of view, there's no advantage at all to limiting the meaning of paragraph 11, is there?
Well, my lord, with the greatest respect, I'm not very happy about approaching that, because that's to say that the drafter would want to have such and such. That's assuming that draftspeople foresee everything that will happen, or and they always take everything on behalf of their client that's available to them. Here we are down the road, whatever it is, nearly a century later, talking about, is it a century later? Oh no, 40, no,
Long
it's not
while
a century,
later, anyway.
It's many, many years later. It does not follow that because you've got a clause allowing departures, shouldn't use the word departures, allowing something to happen to some plots after paragraph 11, it follows that it extends to everything that's possible.
And I see that, but if you were acting for the purchaser of lot 1, it couldn't conceivably be in your interest, could it, to read down paragraph 11? It wouldn't help you at all.
Well, this presupposes that the conveyancer acting for the first buyer is going to give this. This is the process at which they arrive, because if and bear in mind that everyone on this court is a Lord Justice, so you're bringing enormous benefit of legal knowledge and appreciation of what things can go wrong, and no doubt if you took up drafting, that you would include clauses that always have the widest possible meaning on behalf of your client. But we don't know, is the answer, just because, and indeed it's not right to say that because some general words can have a very wide meaning, it means that you have to give them a wide meaning.
And I see that, but this isn't quite the same as Esso or Catry or whatever.
Yeah.
Mr. Catry obviously wanted to confine the power of the employer,
Yeah.
to take away his bonus. But the purchaser of lot 1 would have no reason to confine the power of the governors to sanction a release, to sanction a departure.
He would probably be more interested in knowing what's going on with the adjacent plots. I'm driven to say that because of a point I made earlier on, that we were quite a long way down from the state of the plots, maybe halfway through, then we do need to take the facts of this case as they are known to be,
Yep.
which isn't perfect, to our knowledge, but we know we're not at plot 1 and we know we're not at plot 100, assuming that we're 100 solved. We're somewhere in the middle.
We don't actually know where we are. I mean, all we know is that your plot was purchased subsequently to
Yes.
the defendant's plot.
Yes,
That's all we actually know.
All we know is, I mean, and realistically, what's happened is that a search has gone out for somebody.
Of course.
Who's got something, and so we know there is at
That's
least
why
somebody.
you may not be the next door neighbour, because they might have bought before.
Yeah.
Can I ask you a different question? As I understood the answers you gave to my lord a moment ago, Lord Peter Jackson a moment ago, you're running two alternative constructions of clause 11. One is that it doesn't apply at all to the release or departure from covenants entered into by previous purchasers. So in your case, you're a purchaser of 432. It doesn't apply. The governors just have no power, as far as you're concerned, to release the covenants given by the purchaser of 444, which was a previous purchaser. But all it's concerned with is subsequent purchases.
Yes.
And that, as I read it, is actually your pleaded case and your defence, your counterclaim. But I understood you to say that you have a sort of secondary case, which is, even if it does apply to allow departures from previously purchased, from the covenants given by previous purchasers, in this case 444, it doesn't mean any release of the stipulations, but only a small one. I mean, that's slightly mischaracterising your argument. But that you're saying it's not. It doesn't allow the governors to do anything, but it might allow them to do some things which weren't too significant, too far away from stipulations.
Yeah.
Now that seems to me to be a very different case. I just wonder whether that, as I say, it doesn't seem to be your pleaded case. I just wonder if that's a case that's been argued up until now. Because I hadn't really picked it up from your skeleton. If that's
no, your lordship's right. In reflecting on the authorities and the proper approach, it's not the argument that I'm inviting the court to find.
No, it's not your primary case.
It's my primary case. But in the course of even the dialogue we've had this morning, it has occurred to me that since your lordships are having to arrive at a meaning of this that won't just be affecting my client, but it will be affecting others, that there are other possibilities. I mean, of course we know, because the Supreme Court has done it, that the court can come up with a different construction from one that anybody else has ever propounded. So
as you pointed out to me recently, Mr. Warwick.
Well, but if that's possible, then I perhaps because I'm very conscious of that situation, so I don't want it to go unaddressed. I don't want to find that I lose on my primary case, and you say no alternative was advanced in relation to this, because since we're all into the territory of construction, on which we haven't got any additional information and no one's sought to it, so we have sort of a tabula rasa here, you know, that in terms of how to work with this. So anyway, your lordship is right. This wasn't advanced before the deputy master or before the judge. It really isn't developed in the initial skeleton on which we obtained permission to go to this court. But it is supportable.
So it's what you now want to say.
Yes.
For my part, I mean, not now, but I would find it helpful if you were able to reduce that secondary case to a formulation of what you say the dividing line is between a departure which can be permitted by the governors and something which can't be permitted by the governors. Because if you're right on this secondary case, but not on your primary case, then somebody at some stage is going to have to decide whether replacing a single detached dwelling house with a block of flats of this nature is or is not a departure within the meaning of that bit of clause 11, and for that, I think we'll need some submissions as to what you say the dividing line is between something that is a departure, permissible departure, and something that's an impermissible thing for the governors to seek to do.
Yes. Well, I'm conscious that the way that this has emerged in my own brain, my lord, imperfect though it may be, is that certainly in the courts below, there was argument about what meaning, if any, to give to the second part of the clause, and so we were submitting, and still do primarily submit, that it has no other meaning, or it's duplicatory. But if it's not duplicate, it has some residual meaning, then what is that residual meaning? And my lord, I can certainly do that, and no doubt we can have a but I probably won't be doing it over the short adjournment. I think you're apprehending some short supplemental submissions on the close of argument, perhaps.
Well, I'm also conscious that if I was taken by surprise, Mr. Fane may obviously be more prescient than me, but he may have been taken by surprise as well.
Yeah.
He should know what your case is before he stands up to answer it.
Yeah.
So I'm not really encouraging submissions subsequent to the hearing, but
right.
that you formulate what your secondary argument is in such a way that Mr. Fane can answer it.
Well, I think in that case, I mean, because I once or twice said that we must stick to the facts of the case, that I would be submitting that whatever meaning is to be given to the word departure in that second phrase, it is not sufficient to catch the demolition of the house and replacement by a block of 9 flats.
Thank you.
How are we progressing? We've asked you a lot of questions, but
yes, I've well, in fact, I've finished I've got the 2 judgments and
yes.
the skeleton. The Deputy Master's judgment I probably don't need to go to because you would have read that, and so
yes.
you've plainly got that. I wanted to make a few comments about Mr. Justice, about the judge's judgment, and then the skeleton. I'll try and finish by 1 o'clock.
No, I wasn't. That wasn't the
Yeah.
implication of what I said. Just to make sure that we're on track, as clearly we well are. So.
Yeah, no, we are, because if I leave the Deputy Master judgment, I was going to emphasise paragraphs 58 and 59.
Yes.
And I move on to the judge's judgment, and you've got that in the core bundle at page 56. And I just really wanted to go through certain paragraphs, making short comments. Because obviously it behoves me. I remember Lord Justice Mummery once delivering a very helpful talk in which he told all the advocates that you must tell the judges in the Court of Appeal why the court below has got it wrong. So, so if we go in that judgment to, it starts off by setting out the background, so we can go up to, right, so we go up to page 63 of the bundle, core bundle, yes. Paragraph 39. I simply want to flag up that the judge approached this as an exercise in syntax, seemingly without really giving proper weight to the context. That's why I've been emphasising the context about the nature of annexia, about all the other covenants that are there, and he's looked very closely. I'm not saying this is necessarily the wrong thing to do, because you do look at the semantics, but you don't take one clause in isolation and say this is better English because of the use of the punctuation and that kind of thing. There's a much bigger picture here. 42, paragraph 42, he says, little warrant for reading down the second part of paragraph 11 as if its scope was governed or controlled by the first part. The first part's concerned with the governor's subsequent dealings. The second part reserves to the governors the right to do something else. Now that, somewhere in his judgment, the judge accuses my submissions as being circular. But with respect, this is itself circular. then paragraph 48, the judge mentions in the fourth line, paragraph 8 of the schedule, if the owner of 444 wishes to build on the land, he has to obtain the consent of the surveyor. Its common ground would not be able to act on the consent of the other landowners. This shows that the parties to the October conveyance did not see anything surprising in the governors continuing to have this supervisory role. But this is proceeding from a small point to a huge point, because the fact that the governors may in the other covenants have a supervisory role in some respects is surely inconsistent with the notion that they would be given a free-for-all to do what they liked. Yes, the governors are given some controls, in which case, why do they need to have this massive control for which the defendants advocate? Paragraph 49, the last sentence particularly, which is dealing with my submissions. They might theoretically be possible in a properly worded contract. Much clearer words would be required to appear in paragraph 11. So I'm taking that bit out of context. But the claimant says that once other landowners have acquired rights to enforce, one would not expect the governors to be able to override them by waiving or releasing the stipulations in the third schedule. That will be taking away from the owners the rights that apparently acquired. That might theoretically be possible in a properly worded contract. Much clearer words will be required. I've already made the submission on the basis of some of my cases that this is the wrong way round. That in fact you should be saying that you would require much clearer words in order for the defendant's construction to be correct.
Is that not, is 49 simply, not simply reciting your submission?
Yes. He goes on to deal with them in the next paragraph.
Oh, maybe he is. Maybe in that case I'm wrongly criticising him because he's agreeing with me.
I'm not sure he's agreeing with you, he's just recording what he understood your submissions to be.
Yeah. The paragraph 50 is I think just a repetition of the earlier points that he's made. This is where he's accusing me, I think, of some kind of circular reasoning. And then 51, and it doesn't strike me as surprising the governors should have retained the right to allow departures. The estate owned by the governors was a large one, every reason for them to maintain control over the development. One means of control was to impose and enforce restrictive covenants, another was to allow departures from them. Well, an owner of a large estate will well consider it was able to earn money by charging for appropriate waivers. This is an acceptance of the defendant's submission, but what I haven't said very much, although I did make the point earlier on, it is pertinent that the other party to these conveyances is a long-established charity, and it's not, therefore, a well-known development company. And you might expect, therefore, a degree of careful compliance by the charity when it operates. And so the notion that it will earn money by charging for appropriate waivers, particularly that sentence, we suggest is ill-fitting the circumstances of this case. Because there's no evidence to support it at all. What in fact you've got reference to an order made. This is part of the recitals in the conveyance, and controlling the use of the land. We don't obviously have the order, and we don't have any of the preliminary documentation, but the charity is going to act, we suggest, and to be expected to act consistently within the covenants that are set out, and not to allow paragraph 11 to sort of ride roughshod over them.
That submission slightly cuts both ways. I mean, you're no doubt right that the Whitgift is a very long established charity, and the impression I have is that it has a particular connection with Croydon, and that's where its schools were, that's where its foundation endowment was. no doubt it has a presence in the local community, and the governors of charity will be conscious. But if they simply acted as a greedy developer, purely interested in its own private interest might do, they might come in for some well-merited criticism. But that sort of constraint, which is a sort of moral, community-based constraint, because of the nature of the covenantee, might be said to be a reason not to give their legal rights a narrow meaning, but to rely on these other less legal constraints as fulfilling everybody's expectations that they'll behave decently.
Yes, I understand that, my lord, and that's a view you take. My particular criticism was earning money by charging for appropriate
Yes.
waivers. That crosses over from
Yes, no, I see that.
from the
Yes.
from the legitimate to the illegitimate. I accept that there are approaches that can be that's going too far.
But that of itself wouldn't help you with it. I mean, supposing that it couldn't be anticipated that the charity would charge money for releases, or even that there was some kind of implied restriction on that, that wouldn't mean that paragraph 11 had the meaning for which you contend. It wouldn't suggest that paragraph 11 had the meaning for which you contend, because it could be contemplated that the charity could have other reasons for wishing to relax the covenant regime. And it could then be anticipated that being the sort of organisation they were, rooted in the community, they wouldn't do that in an unacceptable way. Well, I'm only thinking, reminding myself of the interchange we had earlier this morning about going back to the 1940s, whenever the it is the 1940s, isn't it? But, the notion that this charity would be creating a structure that enabled it to make money. You need to go much further than that.
Yeah, well, it may be my submission. I'm probably making the submission because it's the sort of thing that you will submit in probably a non-construction case where you're trying to persuade this court that they should exercise their decision afresh or something like that. I don't think this is going to be the exercise that you're going to be conducting. And then at the end of 52, there's the final sentence: by reserving the power to the governors, the route to a permitted departure is simplified and unified in one party, but in one body. Well, that presupposes, that's to pick up a criticism of me earlier in the judgment, that's presupposing that the words actually have that meaning. And that's the very argument that we're addressing. Because the governors already have control. As we saw, in a number of respects, they have control. You would have thought that if they've already included provisions that have control, why would they want to have this very wide provision that they have at paragraph 11? Why bother with all these other covenants? Why not just have one or two covenants, and all the others are unnecessary? Because you can only use it as you can only build a single dwelling house on it. Full stop. Otherwise, otherwise the user is entirely down to us, or something like that. Far more thought has gone into this, the general covenants, than is suggested by the end of 52. And I, as we'll see in a moment, the route are permitted in one body. This is not little changes. This is wholesale changes. Now, finally, the Maloney Friends skeleton argument, which I probably won't quite get through because there's one case in particular that he's raised that I need to look at. The skeleton is in the core bundle, page 39. And first of all, if I can go on to paragraph 18 of the skeleton, which is on page 42. the Whitgift Foundation's entered into similar deeds of modification and release. Now, this, we say, carries absolutely no weight.
I had struck it out in my own copy.
But if your own...
Unless it features in the reasoning of either of the judges, which I don't think it does.
In that case, can I just refer you to supplemental bundle, page 28, which has my client's witness statement in. We looked before at the preceding paragraphs, pages 28 and 29. My client deals with the two other developments and explains that in one case they were just changing a detached...
Well, these matters didn't
No.
focus in surface in either of the judgments, did they?
No, they're not.
No, they didn't. Well, they're not going to surface now.
They're fine. Good, fine. Then 22B on page 43. This is the arguments against torrential drafting. They say at little b, the second, it allows the governors to modify or release any of the stipulations. So, in fact, interestingly, my learned friend is introducing a new word there. So he's defining the word, the second half of the clause, which is the right to allow departure, to modify or release. So he's redefining whatever that second phrase means.
I'm sorry, which paragraph are you on?
This is page 43 of the core
Yes.
bundle, paragraph 22, little b.
Yes, thank you.
Then paragraph 33, yes, bottom of page 45, he says the reserve right was contained in the same schedule as the covenant. The appellant's predecessors entitled and the appellant were fully aware the benefit of the right was always subject to the government's entitlement to release or modify. That is a classical circular argument, because how could we be aware of that until it's been so decided? And the same goes for little b. The stipulations in the conveyance are in the conveyance of 432. The original purchaser of 432 would have been aware that the covenants could be modified or released by the governors pursuant to paragraph 11. Well, how would we be aware? We wouldn't be aware. And then paragraph 33c, the derogation from grant principle doesn't apply where the exercise of the right is part of the grant. This case here is a case involving a right of entry in a lease, and it's an interesting case because it was a trivial dispute that got to this court, and it was all about whether the landlord could install a bat detector, and it's not a restrictive covenant case at all. If I can just give you the reference to it in the authorities, it's tab 14. This is the case where Lord Justice Lewison was very rude about counsel for the appellant. I'm sure it was all very friendly because they came from the same chambers, but he says at page 261 of the bundle authorities, the tenant's argument. In ICS, Lord Hoffman famously declared that almost all the old intellectual baggage of legal interpretation has been discarded. At times I thought we were being asked to carry the baggage again. And then they deal with, and this case was all to do with tenancy agreements with a right of re-entry in favour of landlords. It has nothing to do with derogation from grant. And the only time you get derogation from grant is at the top of page 262. The argument based on derogation is a circular argument. One can remark on the question whether there's been a derogation from grant. You have to identify what's been granted. True that is. I've already explained how that arises here. So that's the Plymouth case. Oh, and the bat detector is, you'll find at page 270. The judge did his own research on the internet and discovered what an anabat was. It was a bat detector. And so the argument was this was a terrible intrusion by the landlord on the tenant, because they wanted to go in and put up a back detector. Then paragraph 34 of the skeleton, bottom of page 46 of the core bundle, and this is me simply underscoring what I've said several times. A party who has an absolute power of release modification to seek a premium to enable that, and that's is not acting contra. Well, I'm not, as you would appreciate, I'm not arguing Braganza because this doesn't seem to be applicable in this sort of case. It's more appropriate to look at it through the medium of the arguments I've advanced. And then...
I'm sorry to interrupt, Mr. White. The case about the bat detector seems to be authority with the proposition that judges can do their own research on the internet. Is that really the law?
I think there actually is a reference to... There's a reference... I haven't looked up Scott in the Attorney General. Judge may take judicial notice of matters which are capable of immediate accurate demonstration by resort to readily accessible... So, yes, I mean, if that's new to your lordship, then...
I think that is new.
Yes.
Yes.
Well, there you are. You've now got Court of Appeal authority for your internet searches, providing they're on a reliable source.
Yes. Sorry, I interrupted you.
Yes. And then I come to paragraph 37, and this is Maynor and Payne. Now, I won't deal with Maynor and Payne in 1 minute, but I will just...
Is this a good spot to break?
It would be. I won't be very long, but it will take longer than a minute.
I mean, so I think you were going to finish that submission, and then also do what you could to, if you wanted to put any flesh on the bones of the alternative proposition, you have the opportunity to do that at 2 o'clock. If you don't want to do that, then that's a matter for you to decide.
Thank you very much.
All right. Otherwise, we'll break now and return at 2 o'clock, please.
Court rise, if able.